Why do we do history? Because it gives people a tragic sense of the limitations of human nature. You have confidence in it, despite the fact that there is no certainty. The only really reliable way to test truth is through disputation. And that's much older than just the scientific method, because this notion that we can just say, well, we know what justice is, right? I mean, Socrates would just start to rub his hands together. Oh, tell me what you know about justice. There's so much hope. And it's with young people primarily. There is so much desire for truth, to get away from cant, to get away from jargon, to get towards meaning and away from aridity and sophistry and all of these things. It's just so much demand.
Concepts with Sean Whatley.
All right, have we ever got an exciting episode for you today? You'd never believe it, but we got into a great conversation with Ryan Alford. He's a professor of constitutional law at Lakehead University. And we had so much fun talking about these issues that are really, I believe, essential to what's going on constitutionally in Canada. The things that are happening right today in Parliament. For example, Prime Minister Mark Carney's government not wanting to table a budget, or the Emergencies Act we talk about, and the federal court review of whether the Trudeau government was on solid footing to even institute that act during the COVID pandemic. So we talk about everything from history, the application of history right now. Professor Alford says that the historians have turned history into theory. And so they've gone ahead and made history dry and more of a fetish. It's not useful. Fetish is my word, not his word. But we unpack how history, especially when it comes to legal theory and legal practice, is more of a practical tool. We end on a positive note. He says that when we look at countries, for example, in the Eastern Bloc, using the example of Roger Scruton, he spent many years behind the Iron Curtain trying to teach people about fundamental conservative philosophical principles, legal principles, and then those countries have had to rebuild after communism fell. And they have rebuilt. They have relearned ideas and habits and approaches to an ordered liberty. I think we have got a good reason to be confident that Canada has not gone off the deep end. There's a lot more that we can hang on to if we revisit our roots, if we relearn our history, especially when it comes to constitutional law. Anyways, I had a fantastic time. I apologize, my nose is still a little bit blocked up, but I hope you enjoy this as much as I did, and thanks again for tuning in. Dr. Ryan Alford is a professor at Bora Laskin Faculty of Law at Lakehead University. He's an expert on constitutional law. He's practiced law internationally. He's published several books, and he's a senior fellow at the Macdonald-Laurier Institute. Welcome, Professor.
Really my pleasure, Sean. Thank you.
I want to jump right into your book. You published it in 2020, and the title is 7 Absolute Rights, Recovering the Historical Foundations of Canada's Rule of Law. And I want to emphasize that this was 2020, so pre-COVID, and you open your book this way, and I'll ask you to comment on it. Quote, "In moments of crisis, we rediscover both the importance and the complexity of the rule of law. When governments begin to violate constitutional norms at such a fundamental level that it is difficult to point out exactly how this offends against the letter of the law, the concept becomes indispensable, yet it remains vexing." End quote. Explain.
Well, COVID is an excellent example. We had a regulation in Ontario where you could not be outside of your house except during very tightly controlled periods for particular purposes. And you would have people say, well, what's wrong with that? Why exactly can you not do this? And it was not the kind of thing where you could just go into the jurisprudence and say, let me look for an example of when we've done this before and what judges have said about how you can't confine people to their houses indefinitely. Every kind of crisis tends to create new problems. And then we have to think really in a kind of foundational way, about the absolute basic elements of what constitutes rule of law state.
Brilliant. And on that same page, you say this, quote, "The rules of chess do not specifically forbid ending the game by knocking over the board, end quote. And so that's what you're talking about, right? You're talking about things happening that the rule books don't contain.
Right. And that's why we need to have the connection to this tradition. Because if you don't have an animating spirit to your concept of law, it essentially becomes quite impoverished in that form of a rule book or a procedural guideline that is just there to be evaded by clever lawyers as best as they can.
Yeah, brilliant. So before we get too far into your book, I also want to make a shout out to your last book, and it's titled Permanent State of Emergency. And I'll just read this. You're writing about it. You say this, quote, "My last book, Permanent State of Emergency 2017, demonstrated that the United States can no longer be considered a rule of law state, as its executive now has the power to violate non-derogable rights with impunity," end quote. And then on the next page, you say this, quote, "In support of my argument in Permanent State of Emergency, I detailed how, in the 16 years after the 9/11 attacks, the United States gradually abandoned its constitutional order," end quote. So can you give us a definition of non-derogable rights, but then also just those are really strong statements to say that the United States is no longer a rule of law state. So can you expand on that a bit?
Right. So the concept of non-derogable rights came out of the Nuremberg trials. So the idea was at the conclusion of the Second World War, you had a set of Class A war criminals who advanced various different defenses, not the one that we typically think of Nuremberg, which is I was only following orders, because these are the people who gave the orders, right? Their defense was actually this: everything we did was legal. If you watch any kind of cinematic depiction, and there was one done very well, of what's called the Wannsee Conference, which was where the final solution was planned and all logistics put in place, there was quite a lot of attention paid to it being done by legal means. So you had representatives of the Ministry of Justice, of the Chancellery, of all these organizations saying, how can we make sure that this genocide fully complies with German law? And they did so, right? So the idea is there's a certain set of things that you can never do, despite the fact that they would be legal under your domestic legal order. And more importantly, this is an important point also that came out of the Nuremberg trials, is you can't claim that because of a threat to the state, right? Because remember, we declared that we would accept nothing other than the complete capitulation of Germany. We were not going to negotiate an end to the war with the Third Reich. It was an unconditional surrender that would end the Third Reich, was the end state of the Second World War. But you can't say, because of these external threats, well, now we need to abrogate these particular rights. So certain rights can never be taken away, regardless of the nature of the external emergency. One of the ways that that's encapsulated is when Justice Jackson, who was a prosecutor at Nuremberg, said, a country is not a rock. So you can't say you're really defending anything when you take away these protections, because you no longer have any credibility whatsoever as a legal order. That's why it's connected at this root level to the notion of the rule of law. It's not merely that you follow rules. Your rules have to exist to protect exactly these things. And if you yourself are violating these things, for instance, committing genocide, the very basis for your legitimacy is now gone. You're not defending anything.
And clearly I've displayed my ignorance. I called it non-derogable, and it's non-derogable. Sorry about that. So,
well, it's interesting because I just want to point this out briefly. In Canada, when we talk about Section 33, because derogation is normal, right? It's the exception is the non-derogable rights.
Right.
Section 33 in French is called le clause dérogatoire,
Yes.
the derogatory clause. And actually that notion, which comes in via international law, right? The native language of international law at a certain point in history is French, right? It's not really an English word. So there's no really good insight into how you should pronounce it, right? So arbitrary, I think.
So you are magnanimous as well. So I appreciate that. I appreciate that. On this topic of the United States, we haven't left that quite yet, but you say this on the next page, quote, Canada has yet to face a serious crisis of the type precipitated by a major terrorist attack within the nation's borders, a terrifying possibility that many experts posit is a certainty. it is not too late for Canadian jurists to prepare for the onslaught on the rule of law that such an emergency inevitably precipitates. End quote. Now, you're talking about terrorist attacks, but you wrote this literally on the eve of the COVID pandemic and Emergency Measures Act. Would you consider what we went through from 2020 and following to be somewhat similar when it comes to constitutional issues?
Critically, no, because of its resolution. So the point that I came to in that book that you mentioned about the United States is that when the immediate threat had passed, the judiciary had this opportunity, as they always do after a transient crisis, to repent at leisure, right? You sin in haste and you repent at leisure. The courts eventually say, well, Mr. Lincoln, I don't think you should have done that. That was really not acceptable. And then, of course, there's a chastisement and more importantly, an acceptance of the fact that things really went awry. A good example being sort of the post-Watergate period, right? But in the United States, they didn't. And the problem is certain things got solidified into law. Just an interesting point of departure, without going too far down this rabbit hole, is that we had an incredibly portentous ruling from the federal court that said that the invocation of the Emergencies Act was unconstitutional and that the emergency measures passed under it, quite apart from the fact that it was itself unconstitutional, the Emergencies Act invocation. But quite apart from that they were also charter infringing. That's quite substantial. And we never had anything like that in the United States. In fact, you had what kind of motivated me to write the first book, which was the targeted killing of a United States citizen during the Obama administration.
So what you're saying is that Canada came out of this in a better situation than America did. And so on page 40, you say that, and you're speaking about the War Measures Act, quote, its replacement, the Emergencies Act, states in its preamble that emergency orders by the Governor and Council would be subject to the Charter, the Canadian Bill of Rights, and the ICCPR, which is a report of the law, et cetera, et cetera. So just to your point, it sounds like what you said should happen did happen.
Exactly right. So you have essentially a misunderstanding by the government of Canada, to be very charitable, about how the Emergencies Act works. So you had statements, I remember Chrystia Freeland making these statements. Well, what the Emergencies Act says is that everything we do has to comport with the Charter. So therefore, if we do it under the Emergencies Act, it is deemed to comply with the Charter. And that was exactly the statement that was made. And you go back and you say, no, that's not the way the courts are going to look at it. And in fact, they didn't. So again, and this is quite important, even if there had been a proper invocation of the Emergencies Act, which is to say, even if there was cause under the Emergencies Act, because that's a legal question in Canada, right? Whether or not you can bring in the Emergencies Act, the court concluded that there weren't those conditions at the time it was invoked, making its invocation unconstitutional, essentially as a matter of federalism, as a matter of the 1867 Act. But even if that had been correct, the particular measures that did things like debanking certain protesters were charter infringing, regardless of the fact that the Emergencies Act would have authorized them. So that's the whole point. You can't do things that derogate from certain rights, even in the context of an emergency in Canada. And we had a very clear ruling from the federal court reinforcing that.
So just to be crystal clear, did the federal court say that both the invocation and the application were both bad things to have happened? Did they rule against both of those issues?
Well, yes, just with respect to the second, the Charter, they didn't say that everything that was done under those orders was unconstitutional, but particular measures taken were.
Brilliant. Okay, great. And there's just so much good in this book. We're never going to get beyond a few pages, but I just want to keep shouting out here. I love your opening quote here, epigraph, I believe it's called. This is William Pitt the Elder, so an 18th century British writer. And he said, and you quote him saying this, quote, "We all know what the Constitution means. We all know that the first principle of it is that the subject shall not be governed by the arbitratum of one man or body of men." End quote. That almost sounds like a radical libertarian statement of anti-government anarchism. And you're quoting this as, no, this is our historical roots in the English law tradition. Now, am I overreading that, or did you just pick this rare quote to open your whole book?
Oh yes, Pitt, that well-known bomb-throwing anarchist. Well, this is the interesting thing. I mean, it's curious because I've had people who are far more libertarian read that book, and they came away with it extremely disappointed because what they found was that the limitations on parliamentary power are rather modest. I mean, your non-derogable rights do not extend as far as you might think they do. So just one that I always talk about, I talk about a lot in a forthcoming book that's coming out next year with respect to habeas corpus, is that habeas corpus is sacred. It's called the Second Magna Carta by Blackstone. Habeas corpus doesn't mean that you can't be detained on suspicion. It means that you can only be detained on suspicion under carefully specified circumstances and for a limited period of time. And John A. Macdonald complied with that during the Fenian crisis. But what it does mean, what Pitt is pointing to, is that these constitutional limitations, where they exist, are absolute. So that's the line between arbitrariness and a rule of law state. It's not that, you get the right to unlimited human flourishing under the Constitution. It's that the Constitution does restrain every form of power, even legislative power, against some absolute standard, however limited.
We're so used to legal instrumentalism, the idea that we have a social problem, government will just pass a law and fix it. And you're saying, and I believe your book is saying, no, wait a second, that's actually not the system we have in Canada. But I wanted to ask you, now we're just literally on page 1 of the introduction now, and so I want to read this to you. Yeah, because I thought this was also a tricky issue. You say this, quote, "This volume does not address the rule of law as a philosophical concept or as a feature of an abstract legal system, nor will it theorize the nature of its relation to law. Rather, it will describe the substantive principles of the rule of law as it now exists within the Canadian constitutional order, and it will provide an account of the history and the historical purpose of the rights they embed within the specifically Canadian instantiation of the rule of law." End quote. So can the average Canadian be expected to get to that level of, basically you're asking us to learn 800 years of history?
Right. That's exactly what I think is necessary. And I would say that people used to take that pretty seriously. J.L. Granitstein, of course, wrote that book about, how we no longer value Canadian history. This is a real problem. I think that this is really at the heart of what's going wrong right now, is that we don't see why we should do that. But the problem is, and this is the idea of a philosophical concept of law. The idea is we can just tell people, the philosopher kings will come over and they'll say, there's this concept called the rule of law, and it means that, a duly elected government can't do this. That's off the table. And you ask them, well, why is that? And it's like, well, very smart people have figured out that's what it requires. That's no system of justification that's going to work in a democratic society. But what is going to work to convince people that both there is a legitimate basis for the limitation of governmental power and that it's consistent with democracy, right? Consistent with a state in which there is this space to address social problems via the will of the majority, is to say, we've always done this way. And the reason why we are the country that we are is because we followed this historical process to get us here. Right? We learned all of these lessons. They all entered into our historical consciousness. We may not remember them, but they're embedded in everything. Everything that is Canada is a product of this process of historical development. And that's why it has this internal legitimacy. And that's why it's worth learning about, because it tells you about yourself and it tells Canadians about Canada.
In a lecture you gave several years ago at Augustine College in Ottawa, you talked about the disputational nature of truth. Can you unpack that for us?
Well, that too is really integral to our tradition. The idea that we don't have a system of legal authority, which depends upon pronouncement, right? The idea that, let's just say it's axiomatic that the rule of law demands that this occur or this not occur, right? That we're not deriving it out of a tradition that goes back to the philosophes, the encyclopedists, the French Enlightenment. Rather, we're connected to a tradition which has always said the only really reliable way to test truth is through disputation. And that's much older than just the scientific method. The scientific method is essentially one iteration of it, right? That Bacon is operating within a tradition that extends all the way back to Aristotle, where we say there's three essential ways to convince someone of truth. We can have this appeal to emotion, we can have this appeal to authority, or we can use a rational methodology whereby we test propositions rigorously and then accept the conclusion that we arrive at tentatively until such time as we come up with better reasons to refute it. And that sounds really rickety. It sounds like, oh, how could you build anything out of that? It's cards. But that literally is how we achieve any kind of progress, not just with respect to scientific knowledge, but with respect to things like practical philosophy and political philosophy.
I think it's important for people to understand that this is the heart, the literally the beating heart of our whole political system. This need for testing ideas and debating and back and forth.
Words mean exactly what they want them to mean and nothing more. I often think of the harm principle and how that was turned absolutely on its head during COVID, right? It's just, if you have this power to redefine words, if you abandon this notion that no, that they have a meaning, they have a sense that comes out of this rigorous process, that they're a product of all of that, you can just do anything. It's Alice in Wonderland.
One of my favorite lines from Edmund Burke I've been using a lot lately because it's front of mind is, he said, we need to avoid the nakedness and solitude of metaphysical abstractions. And so the way we know what a word means is we go back the 800 years or even 2,000 years or longer to really understand English language. Where does this word come from? If we don't, then we have the beautiful words like in Mark Carney's book, Values, and wonderful words, but okay, they can mean whatever you say they're going to mean, and that's worrisome.
And they acquire that fixed meaning because they're contested, right? I mean, I'm going to be very controversial here and say, when someone says a trans woman is a woman, right? And someone says, no, that's not correct. They are not the karyotype. You're the medical doctor that produces large gametes. That's not what a woman is, right? That they're contesting it. They're saying that we will not accept the semantic extension here because it doesn't correspond with empirical reality. But there's no way that remains where it is without that constant resistance and pushing and disputation that keeps things fixed.
Right. Brilliant. So unfortunately, your comments have made me jump all the way to the end of your book, and you're talking about the common law here, page 178, and you're talking about how modern jurisprudence, modern lawyers are not only have they perhaps had less exposure, or they don't see the importance for legal history, but perhaps they find it a bit frustrating. And you say this, associated with a movement that saw the legal world as one dominated by common law. So they're expressing their frustration with the legal world dominated by common law courts, formal reasoning, and individual rights, and condemned it as both unrealistic and unjust. Unrealistic because its reasoning neither determined nor explained results, and unjust because it masked political and economic values at odds with the values of democratic majorities. And you go on to say that we need to get beyond this disputational stuff and really get a grip on justice and really do good things and be clear and bold and change things for the better. Am I misreading that?
I am. And the problem is that you can see the appeal of this, right? But the problem is, and this is why you need to understand this history. I mean, you want to say, could we please go back and read a little bit of Plato? I mean, would that be helpful? Because this notion that we can just say, well, we know what justice is, right? I mean, Socrates would just start to rub his hands together. Oh, tell me what you know about justice, right? Let's talk about your accurate knowledge of what justice is, right? We can just essentially say, I know what it is because I like this outcome, and so therefore, and that we can just do away with all this complicated business of how we've come to an approximation, how we've managed to come so close to actually achieving something that resembles the common conception of justice by this incredibly painstaking work that we do via the common law system. But instead, just like the philosophe and the encyclopedist, we just say, let's just throw away that book and we'll start writing on a blank slate and we'll get to this wonderful place in no time. That's never gone awry, right? From the time of the French Revolution to, let's say, Pol Pot. It's never been problematic. But again, it's this whole notion of how you achieve truth and saying that, well, once we get frustrated with the notion that the disputation process is not taking us to where we want to go fast enough, that we'll just say, it's okay. I had a prophetic vision, right, about what justice looks like, because that's always what it is. There's a reason why Thomas Sowell called this book The Vision of the Anointed. It's because however you dress it up, it's just someone saying this end state, which is wonderful and beneficial. And, in the morning, men will fish, and in the afternoon, they'll compose poems. For those who don't know, that's Karl Marx. It doesn't make any sense other than just as a vision. It doesn't, because it's not connected to the process that produces reliable truth. It's all just, we'll assume the presence of, all of these things, and they'll just come into being. It's no guidepost at all.
Yeah, but it's a lot more exciting. Roger Scruton said the radical political impulse creates beautiful placards that you can carry in the streets. And he said the conservative jurist is going to write, let's reconsider, let's revisit history. He said it's not a very exciting placard to march to. But I mentioned Roger Scruton also because I was just reading England and Elegy, and he has a beautiful chapter in here on law. Have you had a chance to read his? Yeah, just such a wonderful writer. And maybe you don't agree with what he says on law, but he talks about the English common law approach. And so we've mentioned the disputational nature of arriving at truth. And I'm wondering if there isn't even another layer or element to it. And Scruton talks about how decisions were made. He uses the example of Rylands versus Fletcher, 1865. Basically, a guy created a dam, flooded his property, and then the water seeped into some mine shafts and ruined his neighbor's property. And there was no law saying that this was right or wrong, but the judge had to rule on that case. So the judge came up with the ruling that if you have something on your property that hurts other people, that's a bad thing. And he appealed to the rule of law. And Scruton has this beautiful line. He says this, quote, "This beautiful idea stands in need of a philosophical defense, but to the English it was obvious and was at the root of their respect for the law and their willingness to abide by its judgments." End quote. Can you dilate a little bit on this idea of a common law that exists? It's something that we have an awareness of, and it's not just disputation per se that arrives at an arbitrary ruling. It's actually there's a telos to it. If we mentioned Aristotle, we're trying to actually get at something. Or have I said that wrong?
Well, I tend to approach it a little bit different from Scruton. So here's where maybe the tension between his appraisal of Hegel and mine would come in. But I do have a lot of appreciation for what he said there. I would just take this angle on it. I would say that when there's this novel ruling and you say, well, we've never had this problem before, some people would say what's really explaining how this used to produce results like Rylands and Fletcher would be, it's the application of a common law mind. So the notion of the common law mind, and this is really well elaborated in Cook, he would say it's about this notion that you're never beginning outside of the realm of the common law. You're always looking for analogies, you're looking for guideposts, and you're doing it with this sense that the collected wisdom of the common law is always larger, broader, and more powerful than the wisdom of any one individual. So you get this view, Dickens, if the law says that, then the law is an ass. It's because it came to this wrong conclusion. The common law methodology would say, how can you come to that conclusion? How do you know? Kind of like what they call the parable of the old man's horse, where a series of things happen to this farmer and everyone insists, oh, that's good news. And they say, oh, no, it's bad news. And he says, well, we'll see, right? We'll see if it's good or if it's bad. How can you say over the course of hundreds of years whether or not a court ruling is going to have positive effects or negative effects? But the more that you align it with what exists in common law, the more that you try to fit it within the seamless web, to use Maitland's phrase, right? That when you have that orientation, that it's not about coming to a result in a particular case that you think is the just result, but you do want to achieve that, of course, but it's not what guides you. You get to that telos by a sort of sense of faithful application and faithful kind of subordination of your way of thinking to these pathways, to these methodologies, and that you don't step outside of that. So even when it's very novel within the context of the common law, it's never that you say something, you can never say this is somehow contrary to it, because of the faith of the judge and the judicial role and the sense of the common law as this body of collected wisdom that you'll never surpass.
Brilliant. And so that term, the common law mind, is that your term or is that Cook's term? Or
I don't think it's Cook's. It's the way that we've described Cook subsequently. And I would say it frequently described in that era around Blackstone,
right,
I would
right.
say. So maybe just about maybe a century and a half later. Okay. But while there was still very much this appreciation that we existed in this tradition.
I tell many of the people I talk to, I said, you'll have to bill me for counseling afterwards because you're solving all my intellectual problems. Hopefully somebody finds it entertaining out there somewhere. But I wanted to jump ahead. We're actually only on page 4. We went to the end of your book and now we're back at the front. And you're talking about here, again, this concept of the rule of law. And really you say it's essentially constitutionalism. And quote, no one must be above the law. But then you also say this at the bottom of page 4, quote, it must create unbreakable restraints that bind the executive and prevent it from seizing enough power to obtain impunity and violate those rights in practice, end quote. So we're kind of circling back again to government, what government can and cannot do. And I love that term, unbreakable restraints. And is this still a functioning concept in today's Canadian Parliament? Or it seems like a lot of things the restraints seem to be getting torn down day to day, or is that just my impression?
What we're tending to see is that they come up with novel ways to kind of evade restraint. But it's a kind of a testament to the rule of law. It's kind of like being honored more in the breach than the observance, that they don't attack things head on. You don't have an assertion, as you typically do in these crises of the rule of law, that this problem is just so large that we need to just say we can set aside the law. They come up with really clever and very exfoliated kind of evasions. And the problem is it's this thicket, right? It's not so much a wall as it's just this accretion of brambles. But then when you have the situation where it's like someone is bloody minded enough, or the situation is such that someone has to say, look, no, this really is contrary to a fundamental restriction. I think we're still, this is the ruling of the federal court in the Emergencies Act is excellent evidence of this. We're still in a position where the courts will say, no, there are ultimate limits. You simply cannot do this, which is unfortunately what was abandoned at a certain point in the United States.
And are we expecting our elected representatives to know all this, or is it more like where you fill out your taxes and claim as much as you can, and if they deny it, then you're okay? It almost feels like that's what's going on with Parliament, right? Unless the courts, unless someone challenges it and the court rules, then go for it.
Well, but nevertheless, even if they think to themselves, okay, well, I'm not conscious of the fact that there are restrictions on what I can do, right? It's just how I managed to get this through or what have you. There's always somebody there who's telling them, but you do realize this has to comply with law, right? We don't just, because you have these moments where really, Justin Trudeau, someone with an enormous ego will just speak as if they have the power to call things into being, right? Oh, we all agree that this has to happen or whatever, and that somehow is the prononcement that's going to, and that was COVID, right? Him standing outside of the cottage and just saying these things. But there'll be somebody eventually within government that just tugs on the sleeve and says, well, we have to actually pass the order in council. And it seems like it's just some sort of, a little bit of pushback on Mark Carney too, when he pretended that he was signing things into law, that the cabinet sends that to the Governor General, Mr. Carney. How that works. But regardless of how it just like oh yes, of course, it's just this formality or whatever. The fact that they must comply with the formality is the reminder, right?
Right.
And then finally, what this will get into their mind, and then ultimately they'll be confronted with it, there are actual limits imposed substantively. It's not just a matter of how you manage to go through it, because it is the law that means that they have to do this. And the law will have substantive limitations. And in Canada, uncontroversially with respect to the executive, absolutely, which is why you had this adjudication of the Emergencies Act. Just to give you a different paradigm, in the United States during the War on Terror, legal scholars would say, well, essentially, we're talking about Rule 0 of the Constitution, right? We're talking about Lincoln's argument, right? Were I not to violate the Constitution, all the laws but one would go unenforced. The Constitution is not a suicide pact, all of these things. But it's really implicit in the Constitution itself that in some sort of circumstances, you get to act in defense of the state with no legal restrictions. Something that, as I point out, our legal tradition is the rejection of. You can trace the development of the notion of constitutionalism to the rejection of the idea that in circumstances that are just so vexing and trying, someone just has to say, well, therefore, what I do is by definition constitutional. L'état c'est moi.
Yeah. So it's tricky because we're almost mixing together two different scenarios. On the one hand, you could think of a legitimate concern where we don't have laws in place. The Constitution doesn't seem to address this. So how can we get something done? We need to get done to protect the country or whatever, versus the cleverness of just trying to get done what you want to get done. And so I was talking with Ernst Horscher. I'm not sure if you're Oh, good. Brilliant. Yeah. So he's in his book on prudence, he talks about the difference between phronesis or practical wisdom, and a person who is following practical wisdom is a phronimos, and versus someone who is just simply clever and they're not really doing what they're doing to get towards any kind of common law, telos, good for the country, trying to protect the sense of the constitutional approach in which we live. They just want to get done what they want to get done. Is there a way now in Canadian Parliament, within our constitutional approach, to protect us from those clever connivers and get them to actually act in a way that is more in alignment with practical wisdom in the...
My writing project right now is about how we can instill a culture that kind of enforces that, right? Because I think it's mainly about how we perceive this. Do we believe that this is significant? Are we alive to it? And I would say another possible angle on it is the difference between sophistry and philosophy.
Yes.
Right.
Yeah.
And this connection between the sophists don't actually care about these fundamental concepts of truth and the good and things like this.
Right.
And therefore, there are no restraints on what they do. That's why by the way, it's really interesting. In the history of Athens, the sophists were often very wealthy. And they were very wealthy because they were consultants to people who were going to be put on trial. Because in a Greek trial, you weren't represented by counsel, and you had to just speak for yourself. You had to enter into the oratorium and do this. And the sophists would essentially be engaged by these clients. They'd say, well, you want me because I don't care how you get acquitted, right? I'll teach you how to make every argument in the best possible way, whether it's appealing to emotion. This is why in Aristotle's Rhetoric, he kind of talks about, the courts as kind of a venue for this, right? You make appeals to emotion. You can be, make people cry, you'll win your case, all these sorts of things. Whereas the philosopher would not be engaged, right? Because they're not going to help someone to get that done. But nevertheless, it's always about whether the people watching, right, have this ingrained standard in themselves, right?
Yes.
I mean, you think about the degeneration of American society. Do we think that 12 Angry Men is an accurate depiction of what happened in a jury room now, right? That people would say, oh, no, I am charged with this duty. I'm sworn to this oath. I have to engage in this rational process. I'm not allowed to shortcut it with some sort of heuristic about, well, I don't like the person, or, I don't care, or I have dinner waiting for me, or whatever it happens to be. That we have to instill this culture that prioritizes that difference between sophistry and philosophy, between the person who is concerned with, achieving things through cleverness, and the one who is concerned with achieving things through what is really practical wisdom, right? I prefer the Aristotelian paradigm to the Platonic paradigm, but I think there's a lot of common ground there.
Yeah, there's overlap for sure. So we are going to circle back to that point. We say this, quote, "The understanding of the history that explains and motivates its principles fades with each passing generation, end quote. And on page 7, you even say that it's become passé in some areas to think this way. And so I'm wondering, I'm trying to think of something we can disagree on here. So take this as a friendly pushback. Is this a history professor, a constitutional expert, someone who loves this stuff, just simply saying, come on, people, you really should be paying attention to this, but really you're just living in the world of theory, and you're talking to people who are living in the world of practice, and we all know that theory and practice are living on two different planets. And so, Professor Alford, you're just asking people to talk about these really highfalutin ideas that really are quite impractical. And what would you say to that?
Yeah, it's a good critique. And I'll go back to Granitstein too, and maybe also something I said towards the end of my book, which is that the problem lies with the historians, right? Like, we are the people who are to blame here because we turned history into theory for the most part. We said, it became gauche to say there are lessons to be learned from history. But what's really kind of cause for hope, if I'll foreshadow my conclusion here, which is that the populace still thinks that history is a guide to action, right? The common person is really very much attuned to the argument that you might learn something that would be helpful through history, right? But the historians decided that history should be judged by the standards of the modern research university, and it should have no normative element, that it should be purely descriptive, right? And normally using a Marxist lens, right? So how then could it be anything other than theory? Which is why I am persona non grata in Canadian legal history circles. It's amazing, right? The level of odium that they've displayed towards me. But perhaps not surprising, given that essentially what I'm doing is a powerful implicit rejection of their core methodology, which is to never say that the past should guide what we do in the present.
Wow, that is beautiful. And that line you just said, they've turned history into theory. And that is brilliant. That's what I've been trying to grasp at. We don't value history as a fetish or as a, I just like old things. I happen to like old things, but it's actually supremely practical. It's how we understand what we should do now and how we should make plans for the future. I love that line. It made me think, though, when you mentioned history, and if this is an unfair question, then just dismiss it and say, you know what, that's outside my wheelhouse. I don't want to talk about that. But it made me think of Hegel and history and time moving forward as an inevitability. Now, full disclosure, I am not a Hegel expert. I can barely understand the guy when I read him. And so most of my reading of Hegel is secondary sources. But I'm wondering, is there an Hegelianism baked into modern legal theory that is being taught in schools such that anything old is, by definition, less useful? Because according to Hegel, we got to get it on the right side of history and make sure we're moving forward. Or does Hegel come into any of your thoughts on this?
Well, we're all Hegelians now, effectively, right? We use this language without even thinking of the metaphysical assumptions that are baked in, right? You'll hear people just say things like, use this notion of progress, being on the right side of history, all of that. And you just say, how can you possibly come to that conclusion? When I think about popular history, right? So I don't know if you're familiar with Will and Ariel Durant, right?
Yep.
They wrote this a tremendous amount of popular history. Yep. And they're always talking about how there were all these civilizations that were going along just fine until all of a sudden they weren't, right?
Right.
And what is it that makes us think that we're any different? That there could be, why do we worry? Should we just be like in the Cuban Missile Crisis, when the nuns came into my mom's school and said, you should say your prayers tonight because we're all going to die, right? It's the end of the human race when, Khrushchev hits the button. Should people just say, oh, teacher, haven't you read Hegel? It can't end like that. But by the way, speaking of fallacies in reasoning, right? One of the key ways to illustrate that kind of consequentialist fallacy would be to say, well, it's not going to rain on Saturday. That's when we're having our picnic. We scheduled the picnic. No, it's not Saturday. Come on.
Yeah.
Well, that's not how things work. But this notion that, of course, we're heading along this track, right? And that history has this consciousness to it, right? Which, essentially is divine, right? I mean,
Mhm.
that's kind of core to Hegel. And it, by the way, what makes it really much more like Gnosticism than like mainline Christianity. There's a real tension there, right?
Right, right.
Because essentially it is God knowing itself through the process of history, right? So
Yeah.
once you take out these metaphysical assumptions, you just say to yourself, well, once I say, well, that sounds crazy, which you're loath to do after you've spent several years trying to get through phenomenology of spirit or what have you. I mean, there's an inbuilt bias towards saying, oh, yes, no, I didn't waste years of my life beating my head against this bananas text,
Yeah.
which, by the way, says that the Prussian military state is the culmination of world history, right? So,
Yeah, exactly.
but nevertheless, no, to your point, the notion that we all think, okay, well, things will be better in the future, therefore, there's nothing to be learned from the past. That itself is not new. I mean, it's happened several times when there are these epistemological ruptures that we say, okay, well, then those people were benighted and stupid and nothing to learn from them. That's always been a political program. To some degree, it's the political program of the Reformation, right? To say that the Middle Ages was when everybody thought the world was flat. There was a very famous book called A World Lit Only by Fire, which was this 19th century book about like the benighted Middle Ages before Enlightenment, right? We always say, okay, well, but then you have to ask yourself, if you're being a practical person, who's benefiting from this way of thinking? And it's the people who say, no, this is year zero, right?
Yeah.
It's like, you say that we shall leave the cities, Pol Pot, because we're beginning afresh in history. It's all blank state. Oh, sounds good to me. What were the motivations for someone saying that? And very frequently, within the sphere of politics, it's saying that way of thinking, that what constitutes law is this dichotomy between arbitrariness and ordered liberty, right?
Yeah.
Is something we have to do away with, because that's going to get in the way of us achieving this wonderful future, right? Where everything will be redeemed, right? It's who was it? It was Eric Vogelin who said all the projects of the left are about immanentizing the eschaton.
Oh, brilliant. You read my mind. That's the note I just wrote on my piece of paper right here. I said, you're talking about Vogelin, and really people, we're laughing, but this is serious business. This is what drives so much of the emotion and passion that people put into politics, is they've immanentized, or they've brought into the now, the here and now, and made it real. That's what immanentize means. The eschaton, or the future, or heaven on earth, to use Augustine, city of God, city of man. And we're really talking about city of man and how we should best organize ourselves so that we can achieve human flourishing, and we have laws in place to help us with that, and courts to solve things when we don't have laws, and so on. But there wasn't the same amount of baked in emotion thinking that this is all there is, and this is the eschaton, and this is do or die. And so that's where my head was going. So when you mentioned Vogelin, I was like, yeah, exactly. Now, does anyone talk about Vogelin? Go ahead.
Why do we still read Greek tragedy, right? Why are we still doing this? And why do we do history? Because it gives people a tragic sense of the limitations of human nature.
Yeah.
That is the truest form of literature, right? Like you go back and you read the tragedy of Ajax, right? Something like this. And you say to yourself, oh, it's so true. It has so much to tell me. Something that was written and performed 2,300 years ago, right? Because it's something, it's holding up this mirror, right? These fables that we tell about the perfectibility of human nature, it's wonderful stories. They just have no actual verisimilitude. There I go with the pronunciation, verisimilitude, right? But that's why, this is Winston Churchill's statement about someone being a conservative at 40, being somebody with no brain, right? Because life experience teaches you that you can't expect human nature to change, that there will be no new man that corresponds with Che Guevara's fantasies or whomever, right? That we're just stuck with the human condition. We're living in the city of man. right? And that there's that tension takes us towards ethics. It takes us towards the good, right? But we can't abandon that fundamental bedrock reality of human fallibility.
Right. And you're touching on the pre-Enlightenment questions of who are we? What does it mean to be human? What are we supposed to do with our lives? Is there some way to order our lives? Is there something that comes after this game is up, after we put the pieces back in the box? And all those big questions, which really, certainly in politics from Machiavelli forward, the sense was, it's kind of impractical. We just got to get work done. So let's just do what we got to do. Anyways, we've drifted from your book. Go ahead.
Then why? Well, then why? Right? How can we have? And this is coming to us now. We're seeing that the central question we're facing now. Why do we do anything we do? Why would we want to get along? Why would we want to do these things? There has to be some sort of connection to that answer. And America, was always this notion that there is Jerusalem, right?
Yeah.
And there is Athens, and there has to be all these people. I mean, I particularly like a lot of the work of the West Coast Straussians, right? That there's just so much coming in American history because they're grappling with both of those poles productively.
Yeah. I wondered if you're a West Coast Straussian. Actually, I love a lot of their work, and Jaffa and the whole group. I did read, though. I would encourage you to read. I can give you a link later, and I've done a podcast actually with Grant Havers on his critique of Strauss, and he said he's softened his attitude a little bit on Strauss, and he says, Strauss is wonderful. However, Strauss tends to want to leapfrog over all of Western history, get back to the Greeks, and then kind of defend liberal democracy from this position of being able to uncover the universals that are available within this ancient Greek philosophy and other philosophy at the time, but ancient thinking. And I love that project. However, he's doing it to hang on to his universalism, whereas I would lean more to say, well, even universals, take the most wonderful universal you can think of. The golden rule, agape love, right? Enemy love. How do we know what that means? Well, we know what that means by looking at a particular event in history and trying to understand the story of the Good Samaritan or whatever. And from that, we can grasp at these universals, but we don't come at them in a deductive reasoning way. They're inductive. Sorry, you're going to say something.
I have to. It's like that exact question, right? Go into the Stanza di Raffaele in the Vatican, right off of the Sistine Chapel, the School of Athens, and you have Aristotle, right? And you have Aristotle and you have Plato side by side. Exactly this question, right? And I mean, the more the more we grapple with it, the more insight we get. But again, just to go back where we were at the beginning, it's precisely because we engage in that process that we get insights out of it, right? So it's so great that we have that constant dispute.
Yes.
So much is still coming out of it, right? And that tells us that really is such an effective way to achieve truth.
Yeah, brilliant.
And meaning.
Yeah,
and meaning.
Yeah.
It
Brilliant.
sustains us.
Yeah, love it. So we're getting back to the opportunity. I think society wants this now too. They want to ask the profound questions. And I've said elsewhere that this is, I think, the power behind the Jordan Peterson phenomenon, where he's using his, myth and spirit and using Carl Jung. But you know what? We're almost at an hour, and I want to swing back to your book if we can.
I have to say one thing. Parousia, right?
Oh.
Jordan Peterson, right there. The conviction that comes from having done that, having grappled with all that, having wrestled with God, to use his metaphor, right? That is why when he speaks with conviction, it resonates with people, because it's coming from a place of meaning. That he's recovered through exactly this, not because of some sort of a dry textbook iteration of truth.
And what was the word you used for that?
Oh, parousia, like the process of speaking freely, boldly and freely.
Boldly and freely, yeah.
It's in Demosthenes, and things like
yes.
this. It's like what this time demands is for us to speak in this manner.
Yeah. And the thing that jumps to mind again, I've just got Aristotle on my brain so much the last few years, but phronesis, right? You're dealing with situations that are contingent, and there's an aspect of agency, and you're not 100% sure what's going to happen, but you have stuff to guide you, but it's very much not episteme. It's not book knowledge. It's not definitional, and you have to go through it. And I mean, to bring Augustine up again, right? It's a way. It's a process. It's a journey, as opposed to the Thomistic approach of being more definitional. We better not bring that up, though. That's going to bring a whole another hour of
No, but what we lost and what we get in the common law tradition is we're going back to before a certain key error that Marshall McLuhan and his student Walter Ong talked about, which is when we started to think that things are not completely amenable to axiomatic thinking, are nevertheless not amenable to rational disputation.
Oh, I love that.
It's still rational. The fact that we can never have complete certainty, right? That we're engaged in things that are kind of more in the realm of, of dialectical reasoning in the Aristotelian schema, right? That's the common law thinking that, well, we don't find people innocent, right? We find them not guilty, but we have confidence in it because of the testing procedure. The common law trial is exactly this. We have confidence in it despite the fact that there is no certainty.
Do you have 5 more minutes? I could.
Yes.
Yes.
Absolutely.
So I've got it because
We'll talk less.
this. No. You're not talking. I'm talking too much. So this was a note I had on a question I wanted to ask you. We're going to have to leave out a whole bunch, but this was one I wanted to ask you about, and you've brought it up. At page 7, you're talking about a quote: the British constitutional theorist Martin Lowland, I don't know if I'm pronouncing his name right, noted that, quote, modern practice exhibits an ineradicable tension between the claims of reason and history. Today, it would appear that the claims of reason are again in the ascendancy, and that shapes us, etc. And so my comment in this margin was rationalism, and thinking of Michael Oakeshott and our desire to be propositional in all of our knowledge and textbook knowledge. And so you have that baked into your book as well.
Absolutely. And you can keep going back to rationalism and that essay in politics, and you can say, look at all of the poisonous fruit of this, right? But I think chiefly it comes from, or one way to think about it is kind of trying to definitively separate those things, right?
Yeah.
In a way that we didn't previously. It's that the essence of something, the purity of something. So take, for instance, analytic philosophy, right? And why it seems so arid, right? This splitting down, I mean, some people find Wittgenstein extremely persuasive, right? But there's an aridity to it, and you say to yourself, am I really going to get something that will ever equal what the Greeks did, for instance, in political philosophy, to score one for Strauss, right? Because they didn't rigorously attempt to separate in this fashion, right? The notion that that rather than observing a cat at play, you'll understand it better if you vivisect it.
Mm. Yeah, brilliant. I can't give a big enough shout out for your book. I really want people to go out and buy this book and read even just the preface and introduction are worth the price of the book. And then there's tons of other stuff that you'll love as well. Having said all that, what hope have we for Canada? It seems like where we are now to where we need to be to have responsible government, to have a constitutional parliamentary democracy. Do you see any hope in this? Is there anything that you're aware of in history that we could point to give us a sense of what can we do for Canada?
Yeah, there's so much hope, and it's with young people primarily. And what we have to remember is that Scruton wasn't born Scruton. He went behind the Iron Curtain to teach in underground universities in Czechoslovakia, right? There is so much desire for truth, to get away from cant, to get away from jargon, to get towards meaning and away from aridity and sophistry and all of these things. It's just so much demand. Jordan Peterson achieved that prominence because of this demand. All the stories he tells people coming up to him and demanding this. If we could only see how much desire there was for meaning, and when we tell people certain basic truths, simple truths, right, that participating in a tradition is what makes meaning possible, right? That you're not trying to say that without this orientation and connection to history, that you're merely adrift, that you're going to have all of these existential crises, right? They already intuitively understand these things. Enormous pent-up demand And if you think that history can't change, remember that in 1989, when communism fell rather precipitously, no one in the State Department of the United States was predicting it. It came as a complete surprise.
What a beautiful way to end it. And so there is hope. But, Professor Alfred, I've gotten far more excited in this talk than I expected. I want everybody to know constitutional history and law is just super exciting, and it's the best. If you've listened this far in this episode, thank you so much. Be sure to like and subscribe and tell your friends. And Professor, thanks again for making time for this today.
It's really been my genuine pleasure, Sean. Thank you so much.
Thank you.